We're going to go live. We are live.
Can you hear me?
We can hear Nate. We haven't seen his mic. There he is. He's back. Okay. We are all live, everybody. Thus far, from the little eyeball on the upper left-hand icon of StreamYard, I see 0 people watching, but I know that that's not true.
Probably not true.
No, there were 100 and some odd people in the chat before this even got started. We are going to hear interferences, and by interferences, I mean interruptions. Come here. 1, 2, 3. This is not... Oh, God. Easier than fighting is just succumbing to the fact that your life is over. Your life is over. I'll give him 5 minutes, and then we're going to go. I can't turn the camera around to see Marion, who's not very happy. 5 minutes.
Would you like to offer an opinion?
Ethan, what do you think of New York Times versus Sullivan? Well, I think it's a really weird decision. We should update the sexual malice standard. It's terrible. Just terrible.
So you're a Justice Thomas fan?
Yeah, go. Okay, go. Yeah, we'll be back in a second. Go. Okay, people, we're live. So he's coming back up. This is not going to go on the entire evening. We're going to do an introduction. We're going to set things up, and we're going to talk about what's going on. Nate Brody, upper right-hand corner. So first of all, by way of Viva las Fraidas, I'm going to get to the comments as many as I can, super chats. First things first, by way of vote, who prefers this layout or format? Who prefers this? Don't do that, Nate. That's all part of the debate. To this. That's not an option. That's not an option. This was the other option. That's the same one. What's this? What is this? Okay, so it's either this or this. This, nope, this, or this. Do we all agree that this is better by way of why right now?
Yeah, I'm not sure. They don't know which one is which. Camera 1 or camera 2.
This is camera 2.
This is 2. All right.
Not the thirds. Okay, fine. So I think we all agree this is best. Okay, tonight's live stream. This kid's got to go to bed.
No.
That's right. Fight the power.
That is a good argument. Yes.
When
it's
you get
tyranny.
to when you're
with representation, I got him.
The power always wins. The power is I am the power. I will win. Okay, so tonight we're going to talk. Daylight savings. That's the problem. It's like right now it's only 8:30 to a kid who only goes to bed at 10:30 on an ordinary day. The discussion for the evening is going to be Akilah Hughes, and we're going to do Akilah Hughes in thorough, like beginning to end, because there's a lot of interesting stuff in it. And we're going to do the Trump. Okay, dude, that might get distracting. We're going to do Trump, New York Times, CNN, New York Times versus Sullivan, and all that stuff. Okay,
it is all funny. So I'm good.
It's fun. Now I missed. Seems I missed one super chat. Okay, hold on. The John Beck. Okay, I don't want to miss any super chats. And I see someone who desperately wants to get the kid upstairs. Can you read this? Haha, I thought you were going to pick up Barney. 50-50, your son grows up to be a lawyer or a YouTuber. I'm not picking up Barney anymore. Barney has been 50-50 when I pick him up. High five, and see you later. Boom, shakalaka.
He's looking like a kidnapped victim now. Daddy, I don't want to go. That's how my daughters act too. So,
okay, sweet goodness. Okay, so while everyone sort of floods in, we're 3 minutes in. We'll let everyone flood in. Share the link. I think thumbs up help, but I don't think they really help. Share the link because YouTube does not notify people in a timely fashion, shall we say. I take for granted everybody knows who you two are, but in case you don't, because there's been a lot of new subscribers in the last month, let's start with Kurt on the bottom. Kurt, who are you? What do you do? Tell us.
This way. Kirk.
Right there.
No. I think Kirk is frozen.
Kirk.
He's frozen. He's a nice man.
Okay, you know what?
That's the worst.
Nate, while Kurt unfreezes and warms up to the crowd, Nate, who are you? Tell us about yourself.
My name is Nate Brody. Now let me stop. He's freaking me out.
I'll bring him back.
He's gone.
Remove from stream. Okay, so I think he's gone. He'll come back. But Nate, in the meantime.
Yes, my name is Nate Brody. I'm a lawyer here on YouTube and in real life. My channel is Nate Brody and spelled Brody, like you see down here on whatever this right here. And I like Viva. I do a lot of law stuff. I'm really getting into this law in the hood type scenarios though. So like for instance, my next video is on the constitutional law of stripping. So how the Supreme Court has looked into whether the stripper or people in that particular industry have a constitutional right to actually perform the act of taking their clothes off and how the Constitution protects that right. I'm also going to be looking at the adult film industry too, and to see how the court actually treats those particular pieces of artwork. So that's what I do, a lot of that. I like to just see how the law and how the Constitution really affects our everyday lives. So that's my channel, and I do a lot of other stuff too. I watch movies and do movie reviews. So that's me in a nutshell.
So for anyone who doesn't actually know how Nate and I met, it's the coolest thing in the world. Nate and I met through YouTube because I made the videos about Nicholas Sandman, and I made one video where I predicted that the Washington Post motion to dismiss was going to get dismissed because it was so frivolous and stupid. Nate called me out and said, Viva, you do good videos, but you got it wrong on this video. I then responded to him in a video, and then we reached out. I don't know who reached out to who, and I don't want to take credit. Oh, Uncivil Law is back. I don't want to take credit for having done it. But
I was trying to make the room a little less dark in the video.
He's back. So, Kurt, I'm just saying how I actually grew to meet Nate. So, I think I reached out to Nate and I said, let's do a live stream. And then we did a live stream. We did one, which was Nate's life from beginning to end, plus some law stuff. Then we just started doing it routinely, and then we became friends. I went to New York like 2 weeks ago when I got the shingles.
Not from Nate.
No, not from Nate. In fact, I feel bad because it means I've been carrying it my whole life, and I was hugging Nate while being a carrier of this chicken pox, whatever it's called. It's a Z type.
It's not coronavirus. Just to make very clear, not corona.
No. So I got shingles in New York, and now I'm like thinking everybody I hugged in New York has got to be thinking I got the cooties. And so that's it. Jorge Fabricio says, can I make the triangle spin? No, I actually tried. I can't even get myself on the bottom. This is like the options it gives me. Thank you very much for the super chat, by the way. And thank you very much before it's already disappeared. But first super chat, thank you very much. So that's how I met Nate. And then Nate and I actually became good friends. And we do live streams together. I call and text Nate whenever I have a doubt about not understanding something of American law. I text Uncivil Law as well, but not as often. Just because that's not the relationship we've established. And that's the segue into Kurt, Uncivil Law. Who are you?
Just FYI, you got 2 super chats you just missed.
Son of a bee sting. Hold on. We got okay, we got that
right
one.
Below that.
Okay, we got Curist, Uncivil Law didn't freeze himself. Okay. He didn't. And we got $2 not to crackle the obviously joke. Oh God, obviously and literally. No. They'll never get old, obviously and literally.
Yes.
Kurt, who are you? What do you do?
Well, I'm brand new to Texas, so I'm enjoying my Texas life now. But I'm an intellectual property lawyer specializing in patent law, more specifically specializing in computer databases and search engines is my day job. My background is computer science, is my undergrad technical degree, and then I went to law school. And I produce videos on pretty much everything. I did 9 videos today in a batch shoot. So I got those ready to go and all kinds of good stuff. And the Vic Mignogna fans continue to berate me because I made the mistake of opening my mouth. Well, I've been just trying to field off the comments in both my own YouTube and your YouTube, and it's been super enjoyable.
So here's the deal. We don't have to agree with each other all the time, and we can question each other's knowledge. But thus far, neither Nate nor Kurt have been radically wrong on anything, and I dare say they've been pretty accurate on things. But when you get into touchy subjects that have diehard fans and supporters, you will ruffle feathers regardless of what you do. If you're not what's the word? Definitive enough, or if you're too definitive, if you're too opinionated, if you gloss over a fact, you'll get chewed out. As did Kurt on Civil Law in the last highlight reel that I posted on Vic Mignogna, where I said, I don't know enough about this. I can't enunciate an opinion. Requieta does a good job. Kurt explained some things which people disagreed with. But if you want to see that, it's like a week-old video. Let me just see this. Fleet Lord Avatar says, shake my head, Viva, still not get a mod. I have control issues. I think I've mentioned this before. I don't want to give a mod responsibility or power as relates to things that can be determinate in terms of shutting down conversation or allowing it. So it's a big burden, but I'm going to do it myself. Nope says $2. Ignore the previous super chat. Okay, I'm not sure which one, but no. We got Flat Earth Data says, what about law proving the earth isn't a ball? So I did a live stream with Mark Sargent a long time ago. He will not convince me. I don't think I'm going to convince him. We had a fruitful discussion, and I think anybody whose mind was not already made up might be influenced one way or the other, but it was an interesting discussion. I finally understand the arguments. I just happen to disagree with them. Okay, so what do we say? 10 minutes in. Let's get started. Okay. Kurt, you do IP law, correct? Or you're an IP lawyer?
Yes.
And Nate, you were once a police officer.
Yes, I do criminal. Yes.
So we've got like the three facets of the criminal system here, and I'm a Canuck, Quebecer, schnook who doesn't know anything about American law except for what I've learned in researching all of these videos, and I've learned a bit. Vic Mignogna did nothing wrong. It's not about what you know; it's about what you can prove.
Yeah, that's right.
And thank you very much. Okay, so let's start with Akilah, obviously, because Akilah, obviously, it's phenomenal. It's phenomenal from a legal, just like a copyright perspective, from the YouTube functioning perspective, and then from the legal fees perspective. And it's all, it's amazing. And should I summarize it? I'll summarize it.
Yeah.
Okay.
Here it is.
Not one breath.
Counselor.
Akilah obviously has a YouTube channel. She's a YouTube personality. Her channel has like 150,000 subs. She put out a video in 2006. She's described as progressive. I don't know what that means by Canadian standards, but I know what it means nowadays. But she's described as progressive. She was a Hillary supporter. 2016, the night when Hillary lost the election, she was documenting, their celebratory party, which turned into a funeral by, and she put out a video. It was a 9-minute, 50-second video called "We Thought She Would Win." Akilah documenting the night, the emotions, and how they changed. She posted on her channel. Carl Benjamin, aka Sargon of Akkad. Everybody knows him, or a lot of people know him. I don't know why Wikipedia describes him as right-wing, and a lot of the comments say he's nowhere near right-wing. But setting all that aside, he's controversial. He said some things that can only come back to haunt you in life. He put out a video entitled SJW Levels of Awareness, which was a 1 minute and 50-second re-edit breakdown of her 9-minute and 50-second video called "We Thought You Would Win." The title obviously being, this is the level of awareness of what they refer to as social justice warriors. And it was a highlight, sort of condensed reel of her original video. No commentary, no verbal commentary, some creative editing, and that's it. Akilah obviously filed a copyright claim with YouTube. And I believe it either started with a copyright claim or straight to a DMCA takedown notice, the Digital Millennial Copyright Act takedown notice. Sargon got a copy strike. He filed a DMCA takedown counter notice. The strike was removed, and Akilah sued him in court. Now, apparently YouTube reinstated the video, but Sargon did not make the video public again until the lawsuit was over, just to avoid any potential exacerbated damages if he were to lose the lawsuit. Akilah Hughes sued him for copyright infringement. She lost on a motion to dismiss.
Failure to state a claim. Yeah.
Say it again. Failure to state a claim. 12B6. She lost on that, and then the judge reserved the right to claim legal fees. Sargon of Akkad made a motion to claim legal fees, and she filed a response to the memorandum, or an opposition to the motion for legal fees. And we can go into those arguments soon, but that's a pretty decent summary, I think.
Oh yeah.
Okay, we got here. We ate tea like that.
With the T-shirt, they know I'm not a flat earther.
Oh,
Nate,
that's funny. You were wearing that shirt in the first stream we did together, and I remember that NASA shirt. We know Nate is on. Okay. So, and then we got here. We got Carl is a classical liberal. There's just zero way you can call him right wing if you have listened to a word he said over the years. I've lost all sort of meaning to these distinctions and these. I call them false dichotomies. Because how do you classify somebody? But
I feel like anyone who uses the term right or far right should be obligated to define what normal right is, because far right can only exist as a contrast to regular right. So I feel like anyone who uses the term far right should be forced to define what normal right is, because they never seem to do it.
All that I've noticed is that I can predict what a person's Wikipedia page is going to read like based on their sentiment in, say, social media. Like if I know someone's not appreciated or someone is a controversial figure, somewhere in their Wikipedia page, it's going to refer to them as far right. I know it, and I can draft their own Wikipedia page before I even read it. So I didn't know that Carl was far right, and I didn't know that he wasn't far right. I just knew that that's how they were going to describe him, as they do with anybody who's not popular. And then someone who's not far right is a progressive, and that seems to be.
You've been called alt-right, haven't you, before, Viva?
I have only in the comment section. I don't have a Wikipedia page, and I haven't.
Maybe later.
I mean, I see. Like, I'm worried because I don't know what that entails in terms of implication. But
neither does anyone else.
I'm fairly certain as to where I stand in life, and it's neither left nor right. It's milk toast fence sitter.
So you're Tim Pool. You're Tim Pool.
No, Tim Pool. I think Tim Pool is right. I think he's
Tim Pool is right. You know, I think we can be right on some things and left on some other things. There's some things I am conservative about, but there's certain things I'm liberal about. So, you know, it's I'm on a spectrum. You know what I mean?
Absolutely. And that's what I think is like. It's just a pigeonhole to either validate or discredit somebody on a broad brushstroke scale. With there's no way I can be classified as either one or the other because I know I espouse beliefs that are both on one end and the other of the spectrum. I know it, or at least are qualified that way. Okay, so with Akilah, obviously, a few nuances that I should mention. So she filed the lawsuit. They had a pre-motion conference. Oh, this is one thing I wanted to get into. They had a pre-motion conference before the judge who rendered the decision on the motion to dismiss. Pre-motion conferences, gentlemen, who can explain what that is?
Well, they can be a lot of different things. They can be trial management in terms of different date or scheduling things. They can be status hearings. They can be for a lot of different purposes. But in this particular one, it was in view of the potential motion to dismiss to discuss the merits of the motion to dismiss. So you get both parties in there, and the discussion is, yeah, I'm thinking that you have no cause of action. I just can't figure out if I can do this now or later. So that was the discussion as I understand it.
Okay, and
that's... They can be for lots of different purposes. They can just be very sort of matter of fact scheduling 5-minute things, or they're not usually much longer than that, 5, 10, 13.
So this was, as far as I understood from reading the transcript, there was a 13-page transcript, which I suspect translates into like 45 minutes maximum. And it was a pre-motion conference on Sargon of Akkad's motion to dismiss. And the judge, if anybody hadn't read the transcript, and I included some screenshots, but the judge, who is the one that adjudicated on the motion to dismiss, basically in law, what we would say is grilled Akilah Hughes attorneys, saying, how is this not quintessential fair use? This smells like fair use, et cetera, et cetera. Explain yourself, and as we can say among attorneys, get ready and prepare yourself for the way I am leaning on this file already, because the judge said, I've read the file, I've researched it. You know, we haven't pled the motions to dismiss, but I understand the file. This is my thinking. So, I mean, between the two of you and myself as a lawyer also, like when a lawyer says that to you, and Nate, start with you. When a judge says that to you, like, this is my thinking in the file, what's your reflex as an attorney in terms of how that file is going to go down?
It all depends on if he's saying the right stuff for me or if he's saying the right stuff for the other person, because then I feel like I'm trying to convince him, that my position is better. But again, it's almost reading tea leaves in a way, you know what I mean? Because I've been in situations where the judge has said some horrible things to me and my client, and then came out and was like, all right, but you win, so I'm like, oh, okay, well, great, even though you didn't buy my argument, but it seems like, you bought something. So I don't know. It's a little weird for me because I've been in both situations where it's really good and it comes out good, but then it's really good and it comes out bad. So,
and so Kurt, my work is
transactional, not litigation. So I tend to do a lot of paperwork issues before the patent office, principally. But yeah, so I don't really have this exact experience. So
you know what?
Oh, go ahead.
No, one thing I wanted to ask is that when you were talking about this earlier, we were talking about that there was during the conference, there was a settlement offer, right? There was an offer of settlement, $60,000, and you mentioned it, right?
Yeah, it was after the conference where the judge basically said, here's what I think of the file, and it was shortly after that Akilah came in with the settlement offer.
Yeah, because even that, like, from my understanding, the Federal Rules of Evidence doesn't allow you to mention settlement offers, to the court as some proof of something, except in limited circumstances. You know what I'm saying? So I'm kind of surprised that that's even in the file, or that's even in the case.
Okay, and that's a distinction. So if there's a timestamp on this, let's say 20 minutes the discussion of settlement offers in Quebec. In standard, and I think it's not. I think it's pretty much the same thing throughout Canada. Standard settlement discussions are inadmissible. They're privileged and confidential. They cannot be held against you. In copyright and sometimes in federal court in Canada, you can have these with prejudice settlement offers, which are I'm gonna make a with prejudice settlement offer, which means I intend to put it in the court record. And if you don't accept it, and the final judgment is at least this good or better for me who have made the settlement offer, I then get to use this as evidence to claim back my legal fees because we went through all of this where I offered you something better than what you got, and we could have all saved legal fees. And so in copyright law, I don't know if the principle is the with prejudice settlement offers, but you have what are settlement offers that are to be made at early stages, and if they are not accepted, they can be used as evidence as to how one party tried to mitigate the costs, as opposed to going to the merits to prove that they were right, where they offered something that was along those lines in the early stages. So in Akilah, they had this conference. The judge clearly indicated which way he was leaning, at the very least at that stage. Akilah came back with a settlement offer. I forgot to mention it. $46,000 that Carl should pay her to settle the copyright, which by all accounts was preposterous because apparently she had not registered her copyright, so she was not even entitled to statutory damages.
Yeah, even if she'd have won, it would have been something nominal.
And so it would have been only real damages, and then could she have claimed $46,000 in real damages at that stage of the alleged copyright infringement? So apparently it was like a preposterous settlement offer, which was rejected, not countered, and then they proceeded on the motion to dismiss. But it's an interesting thing Nate said, like sometimes when a judge is hard on you, sometimes they're hard on you because your case is crap, and they want to sensitize you to that. Other times they're hard on you because they want to side with you, but they need to feign objectivity, and they need to feign that they are, being hard on you so that when they rule in your favor, no one can accuse them of bias.
Yeah.
But sometimes you can read in between the lines and say, when a judge says, how is this not quintessential fair use? I am leaning towards fair use. Some reasonably perceptive attorneys should read between the lines and think that the judge means what he or she means when she says it.
It's time to settle. At that point, it's time to settle. It's time to settle. Yeah.
And the settlement might have been, I'll withdraw my proceedings and go ahead and post a video like that. People don't appreciate. Some people would appreciate that as not being a settlement, but rather as a total concession of victory. But sometimes like, okay, I tried. You fought. It doesn't look like I'm going to get very far, so now I'm just going to abandon. Would you please accept my abandonment? And that is still a settlement offer because the flip side is where they're at now. So she lost on the merits, and the merits of the disputes. Who's familiar enough to say because I should stop talking? Kurt,
you got it essentially right. He cut up portions of her videos and without more just reconstituted her videos as a video unto itself with this title that's suggestive of criticism. So, and then she in her own pleading referred to it as, what was the language she used? Because I always get it exactly wrong.
Demeaning, belittling, and I believe it was degrading.
Yes, so criticizing, but yes, the exact language of what he said. And it's like, well, that is one of the essential purposes of both the First Amendment and fair use. So yeah, there's that. My reading between the lines, by the way, is that the amount that she asked for was her break-even point. Because, Sargon is asking for $38,000 of attorney's fees. She asked for 47. So I'm just guessing that was what she needed to break even for her attorney's fees, including the one that from her prior attorney. That was her break-even point.
Yeah.
That seems logical where that number came from, right?
Yeah, it does. It does.
Hold on. What was the question that we were just asking the editing. So incidentally, something I didn't fully appreciate in the first video I made on the subject is the judge said, creative editing or editing can be commentary. But the judge did place a lot of emphasis on the title of Sargon's video. It said SJW levels of awareness was pure critique. So the fact that he didn't say it in the video was sort of irrelevant, but the edit itself was sufficient to transform it into fair use. And the title itself was commentary clearly. And so all of it together by Akilah's own admission, that's where you don't appreciate proper drafting until it comes back to bite you in the butt.
Yeah.
They said in the pleadings it was degrading, demeaning, mocking, whatever, belittling. And the judge, reiterated that in the conference as though that's the purpose of the Copyright Act, to protect someone from belittling, demeaning commentary. It's the exact opposite.
As Willy Wonka would say, strike that, reverse that.
And so I mean, it was crazy. Like, she admitted things which, you can't take back, even if you were an amendment in the United States. Hypothetically, they want to strike the paragraphs that say it was demeaning, condescending. Can the defendant say, I oppose those amendments, leave those allegations in?
Oh yeah, because you can view it as an admission, and you like, no, you can't take those admissions back. So yeah, you can have your amended pleading, but I'm still going back to your original. I'm saying these are admissions, and you can't take those back. So I'll have my cake and eat it too.
and so that's essentially what it was like in her pleadings, in her exchanges with Sargon emails. She said it was demeaning, degrading, belittling, and he's like, yeah. That was the point.
Yes.
That's fair use.
Correct.
That's fair use.
You are correct, Akilah. You have got it.
and that's the issue. Is like the copyright infringement is to protect someone from replicating, unduly copying, and stealing from someone else's market share, not rubbing it in their face and critiquing them. So that's the way it went. So that and the judgment itself, which granted the motion to dismiss, was it's. I don't know. I think it was Leonard French who said it's not going to be precedential, but it's going to be relevant nonetheless. Yeah. I think it's going to be relatively precedential.
Yeah, well, it's not because it will in a sense of it'll be not binding authority, but what's the other one? Persuasive. Yeah, it'll be persuasive authority. But I think it's interesting because this judge has expanded the commentary piece of fair use now.
Yes.
To this editing piece, which I think is relevant. And I think this judge also relied on the transformative nature of the edits because the edits were totally transformed the work. Go ahead.
Do I dare to try to criticize the judge for potential legal overreach? Or am I just asking for pain? Because I feel like to say it's quintessential fair use is a little unfair. I ultimately agree with the conclusion that's fair use, but it's not quintessential fair use. What the Ethan Klein E3 case, that was quintessential fair use. Yes. Right? Because it was taking it and remixing it with actual commentary, actual critique, actual stuff. That was quintessential fair use. I'm on board. I don't really agree with calling this quintessential fair use. I more agree with what you were saying, Nate, that it's more a modification, extension, however slight, of the law to look to the title and stuff as part of the commentary. So, it doesn't strike me as quintessential, personally, it doesn't strike me as quintessential fair use in the same way that H3 case does. That case I looked at and like, this is completely done.
Yeah.
This case wasn't quite that reaction for me. So I did think that language is a little over aggressive for my taste. Not enough to reverse or anything, but I was a little over aggressive.
But I was just going to say so then if you're saying that means then he shouldn't get attorney's fees because it's not quintessential.
Well, that's exactly where I was going. Insofar, so that's interesting. The judge said he asked the question: is this not quintessential fair use? And they said, we don't think so because it's not transformative enough. The judgment said it's transformative enough. It was commentary. It was clearly commentary. And I tend to agree with Kurt. Like it can't be quintessential fair use because it was just an edit. It was a boiled down reduction of the original video with a clear commentary objective. But
it requires more of a critical analysis, right? It requires more of you discerning the juxtaposition of her two comments as distinct and using the one versus the other versus where we had Matt Haas speaking and Ethan Klein speaking. It's very clear it's two different voices, so it's very easy to contrast. As opposed to this video, where it's just Akilah Hughes versus Akilah Hughes. And it's not done like in that Daily Show kind of style where they'll like freeze one side of the screen
and show
and freeze the other side of the screen and have it running, where it's really clear the juxtaposition. So it wasn't like that side-by-side thing. It was, what would be the alternative? It was just one thing followed by another thing, and you had to interpret it enough to see the criticism of it, and the title got you there.
Well, that's the interesting thing, actually. But I'll get to these two super chats before we do it. Lynn Washington, as enjoyable ever and lightning. Thank you very much. And I saw mandatory carry at work. Not enough signal to get through a single sentence, but I'll watch right after I get home. I don't want to get in trouble because I don't know what these hashtags mean. I'm joking. Mandatory. Thank you very much. That is so. I mean, but that's why if these were the only two issues, the legal fees argument might be questionable. It's just everything else that went on in the backdrop and in the foreground. I agree. Like that's the thing. Is like bottom line, there was no mixing. There was no like memeing with it. If someone had not seen the original video, they might have thought that was a highlight reel of Akilah's video.
Yeah, that too.
But without they might have thought it was like a very weird edit, but they could have thought it was just a legitimate reduction with an unintended commentary as opposed to a deliberate commentary. That's where the title came in.
But I hate to defend the federal judge here, but I think you can make the argument that the transformative nature of the piece by cutting it the way they did, it totally transformed the work. That's not what you would have to go see her original work to understand what she was trying to convey versus understanding what he was trying to convey. And I think that's what the judges, when he's talking about quintessential fair use, he's talking about what the work was meant to present. And in fair use, it is about that transformation that I have to actually go watch the original work to actually get the point of it versus just watching your piece and then understanding what the point of that the first work was.
No, true, and I tend to agree with that. The only caveat is that I might have thought after watching Sargon's that I don't need to go watch the original video anymore because I sort of got the gist of what she was getting at, which is one of the other elements of the judgment that I sort of could have reasonably disagreed with, where he said Sargon's crowd is totally different than Akilah's crowd. So the people digesting this work they're not the same audience as Akilah, so there's no market usurpation, which I could think that there might be some arguments to be made there, as in there's no overt market usurpation, but one thing is for sure, Sargon's crowd is not going to need to go watch the original anymore after having seen his remakes, even if it was legit fair use.
That's true.
But so all that comes back to the question as to whether or not Sargon's going to get his legal fees back, because if that were the only nuanced legal question in this file, I think Akilah would have a much stronger argument to oppose the motion for legal fees than she does now, because keep your freaking fights off Twitter. She opened her thumbs to the Twitter world.
That definitely was what's going to kill her, is her opening her mouth. Like, I think she probably would have been okay had she not decided to open her mouth repeatedly as here is my actual motive. My actual motive is to ruin this guy. My actual motive is to take him down. My actual motive is to call him pain and all this rest of it. It's like, well, we don't need a lot of reading between the lines. I think on the original pleading, it wasn't that clear. But Akilah Hughes is like, well, thanks for playing. We really appreciate all these many, many confessions. Makes the analysis way easier. That's great.
Oh my God.
And someone made a great comment. It was on the video, and they said, Akilah's lawyer described it as in the heat of the moment banter on Twitter.
Yeah.
And someone else said, in the heat of the moment.
My response to that is, by heat in the moment, you mean contemporaneous.
So that
would be another word for that.
Yeah, it's called an admission. And it makes it a more reliable statement than a less reliable statement.
I made statements at the exact same time I was doing the thing. Wait a second, no, that means we should probably interpret one in light of the other.
I think it's going to be interesting for about this discussion of their Twitter statements. One thing I got a question one time about hearsay, and they were like, "Well, wouldn't that be hearsay? It's not a court statement being offered for the truth of the matter asserted." But in federal courts, it's a party opponent admission. So it's not considered hearsay at all.
Not hearsay.
Yeah. So
which
even though it is hearsay,
are like, we don't know what the heck that is. Yeah. But yes, the federal
not
hearsay. Say it's not hearsay.
801.
Yes, I understand. Yes.
Yes, but this one would be one that Legal Eagle could talk about in his hearsay video, which would be a statement which is technically hearsay, but probably more reliable than the Viva Voce testimony.
Oh no! It's in the federal rules. It's not hearsay.
It's actually
at all.
defined as not hearsay.
It's not hearsay. Like,
it's
party
defined
opponents
as not
are
hearsay.
not hearsay. You can use them. So if you're if you have a legal issue and you're putting stuff on Twitter from you, that can be brought in a federal case because that is not hearsay at all. Crazy.
So, Dan Larkin, I'm reading the comments as we go through here. I'll just pull up like the ones that we can lead us into discussion. Sargon was actually extremely respectful to her.
Yeah.
So this is the thing, guys. I mean, we're all lawyers, although Kurt, if you don't do much litigation, you probably don't have much opportunity to say to your litigants or to your clients, keep your freaking battles out of Twitter, off of Facebook. Don't post things. Sargon, I say this thing as a rule, 34 minutes, 11 seconds. Draft everything as though it will ultimately be read by a judge. And Sargon must have been, he's got good attorneys, clearly. And he's a smart guy, clearly. And that's not to say Akilah's not smart, and it's not to say her attorneys are not competent. Sargon was abiding by this rule, and Akilah wasn't. Akilah was clearly thinking, what I do on Twitter is my own personal space. Nobody's going to see it. It's like, I've heard some people refer to it as a private Twitter sphere. Draft everything.
I would imagine her lawyer might have given her a note of caution at some point, just speculating there.
You know what?
How do you know?
And having seen the way the lawyer drafted the motion in opposition and thrown the first lawyers under the bus, and I'll get to that in a second, I'm not sure. But either way, draft, and it works for emails, text, it works for everything, voicemails. Do everything as though someday a judge is going to read it, listen to it, hear it. And if you don't think it's a judge of law, maybe think about it like a judge above your head, like a biblical judge or a godly judge. If you think that someone's going to read it out loud in front of people, you'll draft things differently, you'll behave differently. Sargon behaved the way he should have from the first minute, even in their personal email exchanges, which I didn't cover in my video just because I didn't want to get into it. But Sargon is like, you're wrong. Here's your opportunity. Please back off. And Akilah was not receiving to the cautionary words and was not as amenable in terms of the way things were being drafted, and then took it to Twitter. Sargon never took the battle to Twitter, so has nothing to use against him. He has nothing to use in his favor, but he's got nothing to be used against him, as opposed to Akilah, who's got nothing to be used for her in her favor, but a ton to be used against her.
Well, one thing I wanted to add to talk about, because you mentioned it, was about throwing the other attorneys under the bus, right? Yeah. The previous attorneys. Now, I agree. It's usually bad tactic. Don't do it. If you do, you're probably going to lose a lot of points with the judge. But in this case, and again, I'm trying not to get into the ethical issues here, but that complaint originally from Akilah was pretty bad. I'm talking about, it was so bad that it almost, to me, argued fair use for the other guy. Like it literally was arguing fair use. Like it's parliamentary. It's this. And I'm like, who would draft a complaint like this that's arguing for the motion to dismiss for the defendant? Because only he went aside then and said, hey, listen, read her complaint. She says whatever she said is right. It's fair use. And that's all he had to say. Yeah. No, so in that type of context, it's like, I got to throw this guy under the bus because he made the argument for the defendant. You know what I mean?
Okay. Now, here's why I agree and disagree. First of all,
go ahead.
I agree. I agree in the sense that, it was belittling. It was demeaning. It was condescending. That's why I did it. Where I disagree is, okay, new lawyer comes in, Akilah, settle. Here's the problem, and I guarantee you this is what happened, not knowing anything more than what I know, which is nothing. Mm-hmm. I guarantee you she dictated how those proceedings were to be drafted to the first attorneys. First attorneys drafted it, filed it. They saw where it was going. They said, listen to me or I'm leaving. And she says, no, do what I say. So they withdraw. She finds another attorney who pursues it along the same lines that it was originally drafted. Because if I come into that file as a second attorney, I'm saying, fix this and settle it ASAP, because it's not going to go anywhere good and it's not going to go there quickly. But I think she had control over her attorneys and not vice versa, which is...
that's a bad attorney, because I've had clients to say, you should put this in here. And I'm like, hey, I'm the agent. When we talk about legal proceedings, this is what I want to put forward. If you want to put something else forward, fire me and you can write whatever you want. But this is the way this is the way, because again, tactics are my domain. That's the reason why I'm the attorney. And if her attorneys let her write crap like that to argue the point for the defendant, then I think there is some shade to be thrown, because I'm trying to get this. If we now got to go for attorney's fees, I can't just say, the first attorney wrote a bad complaint. I got to now say, I got to try to get her from under this. And what she's under is that her attorney made the argument for the other guy.
Okay, so hold on. We got Nope says part of the reason you won't see Sargon commenting on Twitter is that he was banned from Twitter a few times and got tired of remaking accounts. He might have one now, but doesn't use it much. That may be true, because I saw there was Sargon of Akkad, there was Sargon of Akkad. I was trying to find him to my video to him. So, by the way, incidentally, if anybody knows what his current Twitter handle is, Twitter to me or email to me. So that's a good enough reason. But I think, we lost Uncivil.
Yeah. He said he'll be right back.
Okay, whatever. We'll get him back when he's in. I don't think that's the reason. Nope. First of all, thank you very much for the super chat. It's a legit reason. But even in the private correspondence that Sargon never knew would necessarily be seen by the public, he was biting his tongue and crafting his emails in a way as though he thought and knew that a judge might read them later on down the line. And that's what everybody should do at all times, period.
Yes.
Don't think if you email someone F you that a judge is not going to read that later on, because they will. And so instantly, if anybody's unclear about the throwing the lawyer under the bus, what Akilah Hughes, current counsel did in the motion to oppose in the memorandum to oppose Sargon's motion for legal fees said, I mean, it was nothing more than a one-liner in the original complaint drafted by her attorneys at the time. And when you're a lawyer, that's all you need to say for everybody to know what the heck you're talking about. And it's not nice. Basically saying, I didn't draft these proceedings. I didn't make this bed, but I'm sleeping in it now. And I want to make sure everybody knows I didn't make this bed. But it doesn't go that far. It looks like we lost him. He needs to extract my wine from the freezer. Okay, well, we're going to get Uncivil Law back. But all that says, that's how her second attorney sort of threw the first attorneys under the bus. From an attorney's perspective, you never do it. I never do it because you know that if I do it to somebody else, someone else is going to do it to me. Yeah. It's just like that. The button in the Twilight Zone episode. Nate, have you ever seen that episode?
Yes.
It's the best one ever. If
you press the button.
That episode is the premise of the episode is a stranger shows up to somebody's house and says, "Here's a box with a button. Push this button, and a stranger you've never met in your entire life will die, and I'll pay you $50,000 or $10,000, whatever." Person, hems and haws and thinks about it for the whole episode, pushes the button, gets paid $10,000, and then the person comes back to pick up the box at the end of the episode and says, "Thank you very much. Here's your money, and I'm going to go give this box to somebody else, and don't worry, they're going to be a stranger."
Yes,
that's the way it works.
But don't forget though, they open up the box, they look at the button, they see the button just has nothing. It's like you press, like even if you press it, how would they even know? And they press the button, and the guy walks up with the $50,000. It's a great episode.
It's a great episode. So that's the idea of not throwing your previous counsel under the buses. It doesn't make you look better. It doesn't help your file. It just makes you look worse, and it makes your client look a little worse.
But I agree with all those points. But I think it's like one of those things it's like break glass in extreme emergencies. That's kind of where you do it. You break the glass in extreme emergencies. Sometimes you have no choice.
Okay, we got here Uncivil Law. Sit in the corner drinking wine. Okay, no. First of all, we brought him back. I didn't see him trying to get back in. Incidentally, people, we're at 865 people. 69. Share the tweet. Share the link on Twitter. Whatever on social media. Get people in. I like round numbers. 1,000 would be nice, but that doesn't matter. Okay, so the lawyer throws the other people on the bus in a way, then says, the arguments for why they should not be ordered to pay legal fees, they're beautiful.
Yes. And lame. Beautiful and lame.
Who wants to get the Kurt? You've been out for a while. What do you want? Raise the first.
Well, I for me, where it really went down was right at the end. I actually got up when I live streamed, reacted to it. I actually had to beat my head against the wall because I found it so stupid. It's like Sargon has raised all this money from all these people on GoFundMe, and I'm like, I don't care on any level. This argument is lame, and he raised 80,000 US more than he wound up spending. So he's already been compensated and more. It's filled the purposes of the Copyright Act. His GoFundMe and his success has furthered the purpose of the Copyright Act. And that's when I got up and went into the side room and screamed into a pillow because it was so stupid.
Just so we're clear, Kurt is not mischaracterizing one of the arguments. One of the arguments was he raised so much money on GoFundMe that he's already enriched himself. What did they say? Earned. His earnings. He has net earnings, and that furthers the Copyright Act, which is preposterous.
My brain refused to read it. I had to interrupt myself mid-sentence because I'm like, okay, I actually have to take a deep breath now because this is so stupid. I can't even read it.
The one that I found even more preposterous than that, Lemon GF, thank you very much. Lemon GF is in Britain, I believe, which makes this even later for him. But thank you very much for being here. The other argument that I found even more preposterous than that was, I've already been made fun of on social media, and if I'm ordered to pay legal fees, I'm going to get made fun of even more on social media.
That alone should be a level of awareness video, because in alternative world where she won, that was the result she was hoping for against Sargon. In alternate world, he would have been found liable, and she would have made videos about look at Sargon and how horrible it is, and tweets and look at how he's copyrighting me, and let's go embarrass and shame him for all the horrible stuff. So she's on the wrong end of the paddle. She started swinging, and now I can't feel very bad about it. So that again is levels of awareness. It's like, this is what you asked for, so eat it.
It's pure. It's just pure projection. It's like this was the aspiration, and now that it's not the reality, it becomes the issue, whereas it was the ultimate goal, 3 months ago. The fairly legitimate argument was that she litigated the dispute reasonably. I mean, that's the bottom line. And, set aside the Twitter commentary, it was a legitimate discussion. It was a legitimate debate. She lost, and that was it. It was not patently abusive on his face. And that was the first argument. So the first was that. Second was he made money. Third was if I get sentenced to pay him fees, I'm going to get made fun of even more. The first one, what were we just talking about? The first one was it was a reasonably litigated dispute. That's where I say, but for the fact that the judge gave her,
the warning,
weeks, months to get out of the file before pleading it. That's where I say a judge okay, but we told you where we were going with this. We told you what we thought, and you didn't do anything to actually remedy the specific points of weaknesses that we brought up, other than stubbornly refuse them.
But I. Go ahead.
I was just saying she had this really clever line in there in her response, which was that this was brought under good faith at the time of commencement. And I read that language very precisely. I'm like, I'm not even sure Sargon disagrees with that necessarily. At the point of commencement, sure. But a lot of things happened after that point, including your attorneys warning you and including a whole bunch of other things. So it's I love the way this line is constructed because it's probably very literally true.
But you know what, though? At the end of the day, though, even us at the beginning of the stream, remember we were talking about whether this was quintessential fair use or not and how an argument could be made on both sides and that type of thing. And I think if you're talking about attorney's fees, it goes to the crux. Could she have a true argument? Was this really frivolous? Was this a waste of time? Did it go to any of those key elements that you need to really obtain attorney's fees? And I think an argument can fairly be made that no, the case was brought in good faith. He just used clips. There was no commentary, and the judge found it to be fair use. And I think each one of us can make the argument that the law was extended on this case, right? If this was an appellate case, we'd be saying this is new law. So the judge did make this extension, did find it quintessential fair use. And I think this was something that could be litigated. I still think she could appeal this and say, no, this is not quintessential fair use based on the arguments that you guys made earlier.
They're gonna screw her on all her statements. That's the problem. If we exclude all the motive evidence, then yeah. But unfortunately, we are where we are.
That's the first issue. If it were just issues of law without bad behavior, I think we'd all agree.
It'd be a lot closer.
Well, I'm saying, but that's an appellate. We don't worry about the motives. We worry about the law. It'd be just a question of law. That's what I'm talking about on appeal. It's just a question of law.
Incidentally, what is? Do either of you know the specific delays for appeal? Is it 30 days, 60 days to appeal the decision?
Off the top of my head,
I'm not sure. I don't know.
That sounds ballpark right.
Well, that's it. Yeah. Typically, it's 30 days from the date of the issuance of the judgment, which should be over by now, I think. Anyway, so that's it. Oh, so hold on a second. Fleet Lord Avatar says many of us are banned, suspended, locked out of shadow ban from Twitter. Yeah, well, nobody likes Twitter.
Nobody. Yeah,
Twitter's not good for anything except for sending links to live streams, and critiques about tweets about International Women's Day. Hold on, I can't ignore this. Love you, Viva. Confession of Tyrannus, thank you very much. I like your avatar and I like your name, actually. Okay, so if anybody knows what the delays for the appeal are, I'm curious because I'd like to know when they get past the point to appeal the decision. Even if she could appeal it, I think she'd have to be beyond stubborn to appeal it because I don't think she'll win the appeal. She might just exacerbate the legal fees that Sargon will claim.
Well, I honestly think if you're talking about just the argument of whether it is quintessential fair use or not, I think she could have something, but it all depends on whether the discretion of the judge was it, all that.
Yeah, I think I might have to disagree a little bit on that one. Whether it's quintessential or not, I'm not sure is really the ultimate issue. The awards of attorney's fees under 17 USC 505 are discretionary by the judge, and they can look to, among other things, the good faith and motives of the person who's doing it. It's in the case law, so to look to those motives is part of the awards of fees. So I don't think the finding of fair use is wrong. I wouldn't go so far as to say quintessential fair use. I'd say fair use, but why quibble over that? And as to the awards of attorney's fees, it's going to be an issue of abuse of discretion by the trial court. And when you have all this stuff and you go to the purposes, you go to her behavior, you go to her good faith nature, I'm like, there's nothing for the appeals court to do. Do they really want to say, "Oh, it's fair use" as opposed to quintessential fair use?
I'm challenging the fact that it's fair use, even though we're talking about fair use versus quintessential fair use. I would just say the challenge is fair use.
Okay, well that's
where because if we can number one, the appeal doesn't have to overturn it; it could just send it back to now get past just the motion to dismiss, and now we go to trial. It could just say, well, yeah, this is just not right for a motion to dismiss, send it back, and now you have to just go through the process. That's what I would be looking for in an appeal. And then it also knocks out these attorney's fees because I got it appealed, and now we have to go through the process. So the attorney's fees you got to now look at the end of the trial, not now. You know what I'm saying?
So in light of a pleading that calls it berating and all the rest of it.
Well, no,
no,
just think, I think what Nate's saying, and it's a legit point. This is why the delays to appeal versus the motion for legal fees are relevant. Is if she successfully appeals the dismissal on the 12B6, then it compromises the claim for legal fees. And even if it gets returned back and say go to trial or proceed past examination,
discovery,
yeah. Viva Frei, didn't the end of the judgment say with prejudice? I think it did.
Yes.
I think the dismissal.
But that doesn't mean you can't appeal. That just means that you can't file a new lawsuit. That's what that means. If it was dismissed without prejudice, what that means is that you could refile the same complaint and start over in some court. So dismissing with prejudice means you can't refile. You can always appeal. So with prejudice doesn't mean that you can't appeal. They can appeal. We just don't think it's going to go anywhere, or at least I don't.
Oh, well, that's okay. Now, this is Brian Martin's question. What does Nate mean by an appellate court? Does that have to do with appealing a decision? Yeah. So, first of all, Brian Martin, thank you very much for the super chat. That is the question. So, if they're not past the delays to appeal the dismissal under 12B6, they can appeal that decision. Sure. In theory, the appellate court can say it was premature, it was overtly wrong, it was justified, whatever. So, either send it back for continued adjudication, maintain the dismissal, and it's basically done barring air certiorari to the Supreme Court, or what was the third alternative? I forget which, but basically, if she were to get permission to appeal and the appeal overturns the Sullivan's decision dismissing it, that would compromise by definition Sargon's claim for legal fees because the suit might not be dismissed.
Well, let's talk about for the appeal process, just to even answer this question. And Nicholas Sandman, remember his whole claim was dismissed on a 12B6, and the judge said no, for these three you go to discovery, and that's all she would be looking for. If she can get to discovery with these claims, then I think that almost really destroys the legal fees issue, unless something else comes up later, because now you actually have a live issue. Yeah,
well, that's and I don't know if it's been appealed. I'm just going to see if Sargon, Akkad. I want to see if the decision, what period we're in. I made a horrible. Okay, let's just do this. Akilah, obviously, I think they might be close to, if not past. See, they're 1 month. It's 1 month past the judgment, so I think they might already.
But I think the attorney's fees is keeping that open. I don't think the case is considered closed.
Yeah,
that issue is disposed
no,
of.
but the case is not considered closed. But I would imagine the delay to appeal the judgment runs from the date of the issuance of that judgment. Set aside whatever else has to go on in that file. I would imagine. I don't know.
So is this an interlocutory appeal? In other words, the case is still going on, but it
wouldn't be an interlocutory appeal because we're talking about the case being over one way or the other. So we'd be talking about a final judgment of the court. But I don't know that's final until the awards issues is decided. Because I think hypothetically the district court could undo its old decision, which would be weird as heck. But I don't think it's considered final until the attorney's fees are disposed of.
Okay, well that's something I would like to look into. I mean, I would like to know, and I don't know what's going on here, Leaper. I don't know the answer to that question. That's what I'm curious about, the procedural aspect. If it were in Quebec, the judgment that is susceptible of appeal would have to be appealed within 30 days, typically, just as a general rule. If it's an appeal of right, you wouldn't have to ask for permission. If it's an appeal that would require a permission of the Court of Appeal, you'd have to make a motion for permission to appeal and would have to be granted, then you get to appeal it. This looks like a final judgment. It disposes of the issue. If it were in Quebec, I suspect it would be 30 days from the date of the judgment, regardless of what else happens in the file, because you can always have fights over costs, that can last years, that would not suspend the delay to appeal the judgment itself. So I would imagine, my understanding would be that it would be 30 days. It would be a delay from the date of the judgment itself, which was, I don't know when, but more than 30 days ago. But we'll see. I haven't heard anything about an appeal. I'd love to know if anybody knows if it's been appealed. Okay, that was a wrong comment. That's not what I meant to do.
She's going to have to pay cash for that one. I'm telling you. If she can find an appellate lawyer to file, she's going to have to pay cash.
Oh, yeah.
And
what I would imagine is easy, 15,000, 20,000 without a question.
But I think you can just really sculpt it to be very narrow. That this is just not, this fair use issue should be adjudicated by it's a matter of fact, not a matter of law.
Yeah,
that's really what it's going to be about.
If okay, so to the extent that there's no appeals granted, who's predicting what on the award for legal fees?
Sargon wins 90%.
Okay.
Oh, I don't know. I'm 50. I'm actually 60-40. I'm 60-40 that he loses because it's just hard to get attorney's fees in this. But again, I think I understand the statutes there, but I just don't think there's enough. I think it's crazy, but I don't think there's enough. I think she had a live claim to start, and I think
the thing that's making it more probable for me is twofold. First of all, the amount is relatively low.
Yeah.
If I ask you for $1, you don't have to think about it as hard. And so, for $38,000, it's relatively low, so the judge doesn't have to think about it hard. That elevates in my eyes. The other thing that elevates it is the warning from God, i.e., the judge, who puts you on active notice. I think that elevates it. So I think more likely than that, I'd say 90% is my best guess.
So just because in order to outdo you, Kurt, I'm either going to have to go higher or lower. I'm going to go higher to say he's going to get 100%, and that's my prediction. He's going to get his legal fees back.
Go nuts.
Sargon's channel was demonetized with no reason. He works for YouTube for free as a slave. I'm grateful that he's willing to keep going. Yeah, I heard that his channel was recently demonetized, and people are suspecting as to why. But there's no making sense.
That's a whole subject we can talk about it too. Because none of us are concerned about demonetization issues, right?
No, because this is like you can always find a reason, like, oh, he said this and he said that. But the bottom line is, like, if it's a channel-wide demonetization, and you have to assume he's discussing with people. You have to take for granted it's a deliberate, non-algorithmic decision, and in which case, good luck. Good luck fighting City Hall.
Don't forget PragerU. PragerU just